People versus McKeever.
Good morning. May it please the court, Madonna Blanchard on behalf of the people of the state of Michigan and the Wayne County Prosecutor's Office. I would like to reserve 2 minutes for rebuttal. Thank you.
That's fine.
This case is important because lower courts, victims, defendants need to be sure that the decisions of the reviewing courts will be based on the law, not based on what it thinks this court wants. The Court of Appeals erred because it made its decision based on an interpretation of this court's order, not based on law or fact. The Court of Appeals should be reversed. To answer this court's 2 questions, first, the defendant is not entitled to a new trial where he cannot produce the witness that is the subject of his trial court error claim or claim of ineffective assistance of counsel. At a post-conviction hearing, a defendant must produce the witness that is the subject of his claim. The witness's testimony must be admissible evidence. The testimony must be believable and subject to cross-examination. Without the witness present, defendant cannot establish either error or the result of the proceedings would have been different. Second, a witness's failure to appear is attributable to the party who is required to produce the witness. Here, because it is defendant's claim, he is required to produce the witness. The witness's reasoning for not appearing in court does not relieve defendant of this burden. Ultimately, the Court of Appeals should be reversed because it granted defendant a new trial without stating any legally valid reason to do so. The people stand for questions.
The defendant got 7 to 30 years on the robbery and got time served on the assault, correct?
That is correct.
So the issue of the robbery is an incredibly significant one because that's why he's basically facing up to 30 years in prison. So the question I have is that when you argue that the failure to produce the witness, even though the witness is currently in Texas, what is it that they should have done differently? Like, what is it that what is it that Sato should have done differently? I mean, I'm just trying to understand. You have a jurisdictional issue. The person's living in Texas. They tried to do it by telephonically, but that was turned down by the judge under the court rules. What else should the defendant have to do in this situation? Or if a person's going to face 30 years in prison and we're going to say, okay, you're going to face 30 years in prison because of the actions of your attorney, what I'd like to know is when you have someone in a different jurisdiction, what should they have done differently in order to have this witness here as it pertains to this witness's testimony as to the fact that this witness would have testified that he didn't participate in the robbery?
Well, first we must remember she wasn't always in Texas. It's been indicated to us by appellate counsel that she was in Michigan for some time.
Okay, but she was in northern Michigan, so right. The point is that she wasn't easily accessible.
Well, what we have to look at is the overarching standard here. Now, a defendant is making a claim that the trial court or his counsel erred because he wanted this witness to appear. Now, what is the defendant's burden here? Well, we have to look at that witness's testimony. She needs to be produced so that we can evaluate the defendant's claim. Now, before we do that, as we have here, there's typically an offer of proof so that we can decide whether should we have a hearing to evaluate the defendant's claim. Is there really, here in this case it was his co-defendant. In many cases it's usually alibi witnesses. The defense attorney should have called this alibi witness. Without an offer of proof, the claim usually dies there.
This is where I have a concern,
right.
And I want you to help me with my concern. My concern is that you're the government, right? You have unlimited resources. You have a police department. You have an investigative agency. You have just unlimited state and federal resources that are at your disposal. What I'm concerned about with your argument and what troubles me about it is that you're basically saying that it's the defense side that basically has to petition the court to even get an investigator and has to go and literally jump through hoops to have even the most minimal amount of resources to do their work in a case. And you're saying that ultimately it's going to be the defendant's responsibility to go and track down all of these people, even if these people are out of the jurisdiction. And then when they do track these people down, we're not going to do it telephonically because you objected to that. So it's just the idea that, when you have a resource disparity, when you have one side that has unlimited resources and you have a second side that has virtually no resources, help me to understand the equitable nature when someone's facing 30 years, how we should allow for that.
Right, Justice Bernstein, with all due respect, that's not what I'm saying. That's what the court rules are saying.
No, I understand.
The court will say that a defendant cannot, or at a post-conviction hearing, neither the people or the defense can present a witness telephonically. Next, the defendant has the burden to produce his witness. Now, unless the defendant requests the court's assistance or requests the people's assistance in obtaining that witness, the people cannot or do not interfere with the defendant's witnesses or his ability to investigate his case. We were never presented with, and the court rules provide the defense an avenue to request the people's assistance in obtaining a witness. And when they do that, we have to comply. That did not happen here. So unless the defendant asks the court for assistance, and then the court orders the people to assist the defendant, the people don't volunteer and say, "Hey, do you need some help?" We don't interfere with the defendant's investigation of his own defense without their request for our assistance. So while we do have resources, I don't know if I would consider them limited, but we don't interfere with the defendant's ability to investigate his own case unless we are requested to do so by the defendant or ordered to do so by the trial court. And neither of those situations occurred here. So that's not the people's choice. It's the court rules that have the defendant and the people that have to follow. And without being requested to assist, we don't. There's no requirement that we do. Any other questions? I would just like to note that if allowing the Court of Appeals opinion to stand, I realize that is unpublished, but it sends a message to the bar and people looking at the stability of cases. And the Court of Appeals, one, did not apply any analysis in applying any standard review. We don't believe it applied the correct standard review, but it identified a standard review but didn't apply it properly. And it actually stated that it was doing what it thought this court wanted. And I think that that's a scary road to go down. And I think that if for no reason but that, this court should at least remand it to the Court of Appeals to analyze this case under the proper standard of review, irrespective of what it thinks this court wanted it to do.
Thank you, counsel.
Thank you.
Thank you.
Good morning, Your Honors. Shari Grove with the State Appellate Defender Office on behalf of Mr. McKeever. There are some crucial facts in this case that we don't know and we will never know, but what we do know is that Mr. McKeever was denied his right to present a defense at trial. His constitutional rights were denied by the actions of the prosecutor and the trial judge and by the inaction of his trial counsel. He made it perfectly clear both before and during trial that he needed his defense witness, Jennifer Craven. The prosecutor promised to subpoena this witness, but subpoenaed the wrong witness instead. According to the hearing judge, the trial judge ruled that Jennifer Craven could not testify, and the defense attorney failed to even talk to the witness, failed to subpoena her himself after the prosecutor subpoenaed the wrong witness, failed to object to the trial court's exclusion of the witness, and failed to make an offer of proof as to what Ms. Craven would have testified. On remand, which was years after the trial, this offer of proof was made orally and also through submission of Ms. Craven's guilty plea testimony and her 2 affidavits. I would submit that had this offer of proof been made at the time of trial, the issue would have been preserved because this offer is more than substantial or more than sufficient, and Mr. McKeever would have been entitled to reversal because clearly Ms. Raven's statements were highly relevant to whether Mr. McKeever participated in the unarmed robbery.
There is the inconvenient matter of the video here, is there not?
The video, of course, the prosecutor asserts that the video is overwhelming evidence, but looking at the video, I think it's entirely consistent with Ms. Craven's testimony at the guilty plea and her statements in her affidavits. It certainly appears that Mr. McKeever had an independent agenda in this case in beating up Mr. Fawaz. Mr. McKeever is never seen going into the complainant's pockets or taking the money. It's only Jennifer Craven, who Mr. McKeever may not have even seen, sneaking down the stairs and going into Mr. Fawaz's pockets. He seemed to be concentrating his efforts only on, for his own reasons, beating up the complainant in this case. So I'm just saying that looking at the video, that conclusion is certainly possible, that he didn't know that Jennifer Craven was going to go through the complainant's pockets or take his money. And Ms. Craven's testimony would have been crucial on this issue, whether he participated or even aided and abetted in the...
I just want to understand, so, it's interesting because, I can't see a videotape, but the way it was described to me was, and maybe you can help clarify this for me, the way it was described to me was that as the beating was taking place, she went through his pockets, took the wallet, but the beating stopped at that moment. So basically he stopped beating up on the victim so that not to hit her, and then they did leave together. So would it be your client's testimony that he wasn't aware that she was going and taking his wallet, even though they had to turn him over, and then after they turned him over, she went into his pocket, got the wallet, took out $100, and then just threw the wallet away, and then after that happened, they walked off, in unison. Apparently, but again, I can't see the video, so that's how it was described to me. So is my understanding correct or incorrect?
Well, the video shows, it first shows Jennifer kind of tussling with the complainant. Then later on it doesn't show everything, but it shows the defendant walking in. Then it shows the defendant beating up the complainant, and Jennifer is nowhere around. I mean, clearly he could have taken the wallet at that point if that was his intent. Then he follows him down the stairs. He's beating him some more at the bottom of the stairs. He's beating him as Jennifer sneaks in and grabs the wallet. At some point, he's turned over, but I don't think it's clear that he was turned over by Mr. McKeever for the purpose of getting at the wallet. I think Mr. McKeever had his own agenda, Jennifer Craven had her own agenda, and I think I'm not saying that it couldn't be looked at otherwise in the light that the prosecution is trying to portray it, but I'm saying it's perfectly reasonable and consistent with Jennifer Craven's testimony, and had she testified, the jury may very well have concluded that he was certainly guilty of beating this poor man up, but he was not participating in an unarmed robbery.
So it's your testimony that ultimately there is some ambiguity to this, that there is that it's unclear, that just to understand correctly, that they both had their own agendas, was what you're saying, that basically he was mad, so he was beating him up and hitting him. She went and took the wallet, but that ultimately he wasn't aware that she had taken the wallet. Would that be kind of the type of testimony that we would hear, and you feel that that would have impacted the jury?
Yes, Your Honor, I think that's exactly it.
Okay.
I did want to comment to the extent that the prosecutor in this case is asking for a rule that absolutely requires witness testimony at a post-conviction hearing. I would submit that that rule is inconsistent with current law, and it's inconsistent with everyday practice, and it's far too limiting. There are other acceptable ways to prove prejudice. And in this case, Jennifer Craven's testimony, sworn testimony under oath, is definitely a sufficient offer of proof, and it is definitely proof of prejudice in this case for her not testifying at Mr. McKeever's trial.
Could she have been subpoenaed?
Oh, go ahead, sorry.
Could she have been subpoenaed for the post-trial proceeding?
Well, a subpoena was sent to her, and before she received the subpoena, she had gone up to Oscoda. No one knows where in Oscoda. So a subpoena never reached her. We didn't have an address in Oscoda. We didn't even know what city she was in Texas. So there was no subpoena to enforce. And
the prosecution wasn't asked to assist, or the court wasn't asked to assist in locating her?
No. We couldn't really ask for a bench warrant because she hadn't received the subpoena. In order to arrest her, which would not be
I wasn't
ideal
asking
for
about
a...
arrest. I'm just asking for assistance. Could the prosecutor locate her?
Correct. No, we didn't ask the prosecutor. We didn't know where in Texas she even was.
Oscoda might have been easier.
Pardon me?
Oscoda might have been easier.
Yes, apparently she was staying with some friend in Oscoda, but we tried. I think that's clear from the number of adjournments that we asked for, was that we were trying to get the witness to come to Detroit to testify. And ultimately, we couldn't even fly down to Texas and pick her up because we didn't know where she was. Which is why, even though the court rule may not provide for telephonic testimony at trial, I think a post-conviction hearing is not a trial. I've had judges hear testimony by telephone at post-conviction hearings, and I think in this case that would have been a reasonable solution if the prosecutor and the judge wanted to hear what she had to say.
Do we have to believe, Ms. Grove, that her plea transcript would be admissible at a retrial for you to be able to sustain your burden here?
Yes, I believe it would. Her statements at the guilty plea were self-inculpatory. She did not have really any motive to say that Mr. McKeever had nothing to do with the unarmed robbery. The fact that she said she basically acted alone, it was her idea, is self-inculpatory. I think only if she had accused Mr. McKeever, that would not have been admissible at his trial. But clearly, self-inculpatory statements at a guilty plea would be a statement against interest.
Does it matter that the prosecution didn't have the motive and therefore the ability to cross-examine Ms. Craven at her plea hearing? Because the prosecution wouldn't have known that it was going to be used in a retrial for your client?
Are you talking about introducing it at trial?
I'm talking about the plea itself. In the plea transcript itself, the prosecutor wasn't approaching that thinking, oh, I better ask her some tough questions in case Mr. McKeever gets a retrial and wants to use this plea transcript in that retrial. Does it matter?
Well, I don't think it matters. I think that's the case anytime a witness is unavailable and a statement against interest is introduced. Often there is no cross-examination, but in this case, at least the witness was under oath and the prosecutor could have asked her some questions. The trial judge asked her questions and she testified. It was a statement against her interest, and I see no reason why it could not be admitted as such at trial.
I mean, well, I guess help me with, I see why her admission to her own crimes is a statement against interest. Why are her statements about your client, which are exculpatory as to him, a statement against interest as to her?
Well, her statement is entirely self-inculpatory. I mean, she said she took the money. Her statement that Mr. McKeever didn't have anything to do with it, basically, is pouring the blame completely on herself. So it is a statement against interest. And in People versus Berea, it's very similar because the co-defendant's statement, it wasn't a guilty plea, it was a statement to police. But the co-defendant's statement was self-inculpatory and also exculpatory as to the defendants, at least somewhat exculpatory to the defendants. And that entire statement, the court ruled, should have been admitted as a statement against interest. And in that case, the defendants were charged with aiding and abetting. And in this case, Mr. McKeever was charged, well, the prosecutor argued that he aided and abetted the Jennifer McCraven. So I think her entire statement would have been admissible, even though it contains some statement saying that Mr. McKeever didn't have anything to do with it. But taken as a whole, it was a statement against interest. And I just feel that it would have been admissible at trial, and it should have been enough at the hearing to grant a new trial.
Okay, well, thank you, Ms. Grove. Your time is just about up now anyway. Are there any further questions?
Okay.
Okay, thank you very much.
Okay, thank you.
Thank you, Ms. Blanchard, too. Your time is up.
No, I think
She had a lot of
she has
time
some time.
Did you reserve any time?
I reserved 2 minutes, but I ended at 8 minutes.
Well, okay, take 2 minutes, please.
I would just like to make a few points. First, that the defendant was convicted under an aiding and abetting theory. So the statements that the appellate counsel wishes to admit that co-defendant stated actually would make no difference on the outcome. If she didn't tell, she says that she never told the defendant her intent to rob the victim. That's okay, because while the defendant is beating the victim up, his state of mind and what he thought was going to happen could have changed. That's what we can infer from the video and the victim's testimony. So that could have developed as the assault continued. So the fact that she didn't tell him in advance makes no difference on the outcome of the case. And that would be the only part of the plea transcript, or if we were going to look at the affidavit in isolation, that would be relevant here. None of the other statements that Ms. Craven made at the plea transcript would be admissible. We wouldn't admit the whole plea transcript if we first had to decide that she was unavailable. then we would have to decide whether there's a statement against interest. And so we would have to look at what would be admitted in the plea transcript, and that would be the only part that would be relevant here, the fact that she pled guilty to another crime. But then that wouldn't be a statement against interest, the fact that she didn't tell the defendant that she had the intent to rob him. But let's just say that that part was going to be admitted. Well, that would make no difference here, because that may very well may be the case. But that changed as she's searching through his pockets and he's continuing to beat the victim. Then he flips him over and she's searching through his back pockets as he's continuing to beat the victim. And then she gets the wallet and then the assault ends. The jury could infer that his intent had changed throughout, so her testimony wouldn't have made a difference if even that small portion of the plea transcript could have even been admitted. Arguably, I mean, the people contend that it wouldn't be, but it would have made no difference. As far as
is your view that there is nothing else that's really necessary to know apart from the fact that at some juncture he became aware that she was rifling through his pockets and eventually took the victim's wallet, and that he continued to pummel the victim at the same time, and that presumably that pummeling assisted her in rifling his pocket and taking the wallet? Or is there something that she could have said concerning her initial intent and his initial intent in going to the crime scene, and that they varied in some significant enough way that there was insufficient evidence to sustain an aiding and abetting conviction?
I would go with the former. My view is that there's nothing that first she can only say what her intent is. So there's nothing that could have changed the outcome based on what we know she would have said. She can't say what defendant's intent was, how his intent changed, what happened in the middle, or what he told her after. What he was thinking about. That she can't testify to that. All she can say is that she didn't tell him that she had the intent to rob this person. What he was thinking when he was assaulting him, she would have no way of knowing, or no foundation to make.
Is it at some point, though, fair to ascribe to him the intent, or at least the knowledge, that his pummeling of the victim was assisting her, or is that ascribing too much in terms of what's required in an aiding and abetting relationship?
I think that it's fair to say that his, to use your word, pummeling of the victim was aiding and abetting the co-defendant's search for a wallet. I mean, that's what
even though that might have not have been his initial intention, or even his intention at some later point.
Even though it might not have been his initial intention, what his intention was at some later point, we would not know unless he testified. He doesn't contend that he can offer any of that evidence, or what he was thinking as he was pumped. The fact of the matter is that no, we don't need anything else. We don't need to know what he thought of before the assault, and we know what he was doing in the assault, so that is enough. His aid and encouragement for the co-defendant's search of the wallet in and of itself is enough to support it.
Refresh my memory. My clear recollection of the video was that they walked out together after the pummeling. I'll call it a pummeling. After the pummeling and the robbery from the victim. Did they appear on the scene together too? Do we have a sense of whether or not we have a sufficient perspective on the totality of the circumstances here to know that they appeared on the scene together?
We don't know. Based on the record, there's on the trial court record, that is not reflected.
Does the departure from the scene give you any basis for a reasonable inference as to any aspect of the crime here?
Yes, it would reasonably infer that he was aiding and abetting in the unarmed robbery of the victim in this case. As the larceny was happening, or what started, continued, and then as they were leaving with the items. I'd also like to just address appellate counsel's notion of the rule that we're trying to establish, requiring a witness to testify all the time. That's not what the people are saying. It depends on a case-by-case basis and the claim that the defendant's raising. In this case, we can't decide, or the courts can't decide, whether the co-defendant's testimony would have either deprived defendant of a substantial offense or make any sort of standard of review analysis without the witness's testimony. What we would have here is we have an uncooperative witness now, somebody who doesn't want to testify for the defendant anymore. And if this court, as the Court of Appeals did, permits the retrial, all we're going to have is another trial based on the same exact evidence without this witness. We have an uncooperative witness. Arguably, the plea transcript's inadmissible, so we would have another trial based on all the same facts. And that just can't be the case. That's why the defendant has to produce the witness so that, one, to even get there, so we can make a determination whether that witness's testimony would have changed the outcome or under either any applicable standard review, it arguably is unpreserved constitutional error or under the Strickland analysis. And we can't do that without knowing what she was going to say, whether after she's subject to cross-examination, whether she's believable, and what part of her testimony is even admissible to decide whether there would be a different outcome at the trial. Any other questions? Thank you.
Thank you again, counsel. Thank you, Ms. Grove.